everyone. I'm Richard Mear and I'm the head of the International Department at Day. Welcome to this discussion on resisting slap suits and challenging corporations that weaponize the law. The right to freedom of expression is a fundamental human right enshrined in Articles 19 of the Universal Declaration of Human Rights and guaranteed under Article 19 of the International Covenant on Civil and Political Rights, as well as Article 10 of the European Convention. This right can be subject only to restrictions which are prescribed by law and necessary in a democratic society in the interests of national security or public safety, public order, the protection of public health or morals, or the protection of the rights and freedom of others. Under the UN Guiding Principles on Business and Human Rights, business enterprises, which includes law firms, have a responsibility to respect human rights, which requires them to avoid infringing the human rights of others, to address adverse human rights impacts with which they are involved, but also to carry out human rights due diligence. It is of grave concern that there's been an increasing trend across the globe for some corporations to use oppressive lawsuits and legal strategies to silence critics and stifle legitimate opposition to their business activities. This phenomenon is known as slapping, SLAP being an acronym for Strategic Lawsuits Against Public Participation. A well-known example of a SLAP suit in the UK was the McLibel case brought against campaigners by McDonald's in the 1990s. SLAP suits have been deployed particularly against environmental organisations, human rights defenders, and journalists speaking out against issues concerning the environment and human rights and corruption. In a case brought in South Africa by Mineral Sands Resources against environmental activists that we shall hear more about today, the judge observed that mining companies are claiming inexplicably exorbitant amounts of damages, which the claimants can ill afford. They instituted proceedings fully aware of the fact that there is no realistic prospect of recovering the damages they seek, and that the action brought would, without a doubt, place an economic burden on the defendants. She went on to say that public participation is a key component in environmental activism, and the chilling effect of a slap can be detrimental to the enforcement of environmental rights and land use decisions. Published today on the Business and Human Rights Resource Centre website is their report entitled Slapped But Not Silenced: Defending Human Rights in the Face of Legal Risks. The executive summary, the Business and Human Rights Resource Centre identified 355 cases filed since 2015 across the globe, a figure which it says is likely to be just the tip of the iceberg. These cases were brought or initiated by companies and business people in several sectors, with most associated with mining, agribusiness, logging, and the palm oil industries. According to the report, the total amount claimed in just 82 cases that were assessed totaled more than $1.5 billion US. The report noted that slaps are in part made possible by law firms and lawyers agreeing to represent companies, and it identifies 19 law firms involved in slap suits. The foreword to the report states, "It is extremely concerning how slaps have become a staple in the manipulation of the judicial system by business actors to stop legitimate human rights work, restrict civic space, and repress dissenting voices. Slaps drain the resources of defenders, take time away from human rights defense, and intimidate others from engaging in legitimate human rights work." And I should mention that a link to that report is on the Q&A function on this webinar. And if you've got any, I just mentioned this now as well, if you have any comments or questions that you want to raise that we can discuss at the end of this session, please put them on the Q&A function. Now, here today to discuss slaps and what can be done to stop them, I'm delighted to be joined by three lawyers who've been fighting at the coalface in this area. Jill Phillips is the Director of Editorial Legal Services for The Guardian, where she's advised on phone hacking, WikiLeaks, the Leveson inquiry, Edward Snowden's NSA leaks, the HSBC files, and the Panama Papers. Leanne Govinsamy heads the Corporate Accountability and Transparency Program at the Centre for Environmental Rights in South Africa and was formerly head of legal investigations for Corruption Watch. Charlie Holt is legal counsel for campaigns at Greenpeace International and has been involved in defending SLAPPs brought against Greenpeace in the US. He's now working on building SLAPP resilience in Europe through CASE, the Coalition Against SLAPPs in Europe. So if we could start with some background. Jill, perhaps you could tell us, first of all, exactly what a SLAPP suit is. Jill, I think you've got your mute button on, so you need to unmute yourself.
I'm unmuting. Yes, that Richard, it is the $100 million question. What is a SLAPP suit? In a way, it's the sort of it's the elephant in the room that we all sort of recognise, but it's quite hard to pin down when it comes to it. And you know, there have been various attempts to define it that I think have got somewhere now. I think there are some common themes that people would say you would expect to see in a SLAPP suit, but just taking a couple of steps back, I mean, the term SLAPP, as you say, strategic lawsuits against public participation, and it was a term coined really by a couple of US academics back in the 1980s. One was a law professor, George Pring, and the other was a sociologist, Penelope Kanan. And between them, they sort of noticed this phenomenon that they had first started being talked about in the 1970s, about the law being used to stop people speaking out. And it started out very much as a sort of community-based thing, you know, people who were wanting to talk to their local MP or equivalent in the state, their councillor, about something consumer, environmental, or something that was concerning them, and suddenly finding that they were being subjected to a threat of law if they talked about it, and then the community rep being subject to that, and that sort of expanded into protests, bigger protests, you know, consumer boycotts, to people writing pamphlets about things, and ultimately, from my sort of neck of the woods, led to the media, who would be reporting on these things once they got to a certain level of interest. The media would want to report on them. So there was this sort of collective spotting, if you like, by the sociologist and the law professor that these things were going on, and they came up with this phrase and talked about how the law was being used to silence people. And this was very much, you know, this is America, this is the First Amendment, very strong protection, a really strong protection on political speech, if you like. And this is sort of, you know, community speech, which also is very high value in the States. So all of that sort of feeds into them coming up with this term, and then doing a couple of papers that started setting out some of the things that they'd noticed that were, if you like, common factors. The volume of the use of the law, the fact that it tended to be directed against individuals, the sort of speech that it was trying to stop. And, you know, again, one of the big issues that I think came out of that is, was it key whether there was any legal basis for the complaint? I mean, I think that's one of the really tricky areas here. Quite often there might be some grounds for a complaint. Someone might have got something slightly wrong, they might have misunderstood something, they might be reporting a rumor, and where that fitted in, you know, did that mean that was the end of it ever having a chance of being seen as a vexatious piece of litigation? And I think there's a sort of proportionality test almost that lurks in these things. You know, is using the law, using a sledgehammer to crack a nut? Are there other routes that you could legitimately go to? And as Charlie and Leanne will talk about really from the environmental front. This then sort of grew from that to being deployed against these much bigger targets, Greenpeace speaking out against environmental abuses as they saw it, and being clobbered with enormous lawsuits on defamation, to, if you like, in the UK, to the Benny Steinmetz doing the data protection, data subject access requests to Global Witness. The purpose of these things is not to win. It's to divert and silence. And to that extent, whether there might be some small grounds for complaint, may not, is not really the thing that's in issue.
So it's right to say then that the key feature is, these cases can be meritorious legally, but the point is that the purpose in bringing them is to silence rather than to secure a legal victory on the merits of the case.
Exactly. You mentioned McLibel. You only have to look at McLibel. All that time and money and effort spent by McDonald's in pursuing Steele and Morris, and at the end of it, McDonald's did get a small victory out of it. I think there's a very small award of damages over a couple of things in a great, enormous set of things. The costs and the disproportionate censorship and chilling that it had on that debate, out of all proportion to what was really behind it. So yeah, sort of spot on in that sense.
And what you mentioned defamation in the McLibel case. Obviously, that was a live case, and a lot of these cases, as I understand it, are defamation cases, but it can take other forms. Is that correct? SLAPP suits?
Yeah, a SLAPP suit is just the use of any litigation to, with the ultimate aim not of winning or losing, but of silencing or diverting resources and time and effort. So copyright is used, data protection is used. Defamation is a good one because a lot of this, in terms of protest, if you like, and speaking out about things, manifests itself in speech terms. So it goes to the heart of it.
And would it be broadly, would it be reasonable to suggest that environmental organizations are often a significant target of these SLAPP suits?
Yeah, I think, Charlie and Leanne again will speak to this more directly, I would think. But yeah, absolutely. From Greenpeace, who have been subjected to this sort of suit in enormous ways, in logging and pipes in America, through to, I guess, the protests that there have been here against people protesting against roads and runways and that sort of thing. The use of intimidatory injunctions against some of those groups, is a balance between the public damage that may be being done in some actions against their right to speak out about what they don't like. And so, yes, you see it deployed in those things. I think increasingly it's moved, or at least we're recognizing it as having moved from that sort of environmental protest sphere into just being deployed against people who are saying things that rich and powerful people don't like. So, governments, high-level politicians who you might expect to take criticism of part of the democratic political process, in some countries still feel the need to be issuing libel suits left, right and centre just to shut people up who disagree with them, with their political opponents. And the same with business and that sort of thing here.
Now, you said that the cases really began to develop in the US, and I think in Canada as well. I've seen that there were cases there. But in both those countries, there has also been quite significant developments in defences to SLAPP suits. Is that right?
Yes. So, once these academics had recognised that these, put this together as a group issue, what came out of that was that certainly in the US, and that's then moved into Canada, they started to develop some procedural safeguards in terms of the court cases. And many states in the US now have their own laws, or there is a uniform law that's drafted and available that states can sort of sign up to. But basically, it's setting in place a number of procedural safeguards. So if you think that there is something that is a slap suit, you can sort of tick a box, and it then goes off down a route which allows for an expedited hearing. It allows for a dismissal motion effectively to be made to get rid of it quickly and cheaply. It knocks out disclosure, which of course, as we as litigators all know, is one of the most time consuming and difficult things to deal with. So it knocks out or limits the disclosure route, has a small quick mini trial that basically says, well, is this a speech issue? If so, we're going to push it this way. And it allows in some instances for a shifting of the burden of proof in that initial stage, and it can impose cost sanctions on those who bring such suits once they're identified as such. So, it sort of takes them out of the main process for a bit, looks at them, says if they're this sort of thing that tick all the right boxes, then you're not going to be able to bring this case, basically. So, and of course, we don't have anything like that here in the strict sense. There are bits, as we can discuss later, in both the Defamation Act and the CPR that you could use possibly to go down that route.
So, as I understand it, in Canada, the Supreme Court has laid down a principle in which you have to weigh up, on the one hand, the public interest in protecting the right to the defendant's freedom of expression on the one hand, and on the other hand, whether the claimant, the plaintiff, has actually suffered any significant harm. So it's a kind of a balancing exercise that they go through. Is that right?
Yeah, absolutely. The public interest is at the forefront in terms of the protection of the speech. Again, that's a theme that runs through these. This is public interest discussion, if you like, criticism, etc.
And in the UK, you mentioned the UK, we've been a bit slower to get off the mark. And I've seen it mentioned that this is to do with the approach that's taken to Article 10 of the ECHR and the need to balance the rights and responsibilities, the way that is approached in the EU. Is that?
Yeah, I think in part that's the case. I mean, in the States, the First Amendment is a much more absolute right. And therefore, it's not a balance. You don't do a balancing exercise in the States when you're looking at First Amendment rights. Whereas, traditionally, as we all know, Article 10 is a qualified right and has specific bits in Article 10.2 around the rights of others. And so it has to be a balancing exercise. And I think that's therefore made it a little slower to recognise the value of protecting this sort of speech, although there is an increasing body of law coming out of Strasbourg that absolutely goes down that. And for a long time now, Strasbourg has recognised that political speech is deserving of protection. So you sort of think, in the wider definition of political, from community speech to activism to that sort of thing, this sort of speech would be protected and recognised by Strasbourg. And then it's a balance, as you say, again, the same balance about what other rights are infringed. I mean, it's interesting in the sense that a lot of what we're talking about is big business, rich people. So, the rights that the qualifying rights that they might have would be reputational rights, which now, of course, feed into Article 8, but they don't, business doesn't have any privacy rights in that sense. So they're not going to be able to use that route. So it's sort of, it is sort of settling down that there's definitely a route there to recognise and protect this sort of incident and give it this name, and identify it for what it is.
Well, that's really helpful, Jill. Thanks for that background. And perhaps we could just move on to talk about some of the cases and the global growth in the use of SLAPP. So, Charlie, I mentioned in the introduction the publication of the Business and Human Rights Resource Centre report today. You obviously know about that, and perhaps you could just give us a very brief summary of what the report said.
Absolutely, and thank you, Richard. Yes, the report that was published today by the Business and Human Rights Resource Centre is a really valuable resource. It's a hugely ambitious project, and I would suggest to everyone to take a look at it. It's a global analysis and global database of SLAPP cases. They've recorded 355 SLAPP cases from around the world. And in so doing, they've been able to see where there's a real concentration of cases. So, for example, they found that there's 38% of the cases they have are in Latin America. And so I'm going to be a bit low on my numbers here, but the second most is in Asia, and then there are 18% in Europe. So they've been able to do that. And through the analysis, there's an accompanying report. There are a number of videos that you can watch. They've been able to take out and identify some of the key common qualities that you see in SLAPPs and really show a pattern in the way that these abusive lawsuits are being used. And I think this is a really important analysis, mainly because, well, for two things. First of all, our efforts to collect data on SLAPPs have been somewhat sporadic. There have been various different attempts in different regions. In the US, you've already mentioned Pring and Canaan's research. In Europe, we've recently been trying to catalogue and identify a list of cases. We've got a list now of 280 cases over the last 10 years. But worldwide, you haven't seen that attempt to put these cases together. And secondly, until now, or till recently, our knowledge of the growth of SLAPPs has been largely anecdotal. And what this report has done is really to put this down into concrete numbers, which I think is important. And again, in Europe, through the Coalition Against SLAPPs in Europe, that's something that we've been recognizing and trying to quantify and had to some extent been able to do in recent years.
Thanks. And I mean, perhaps we could now talk about some of your experiences as a lawyer with Greenpeace in the US. I believe you were involved in a couple of big cases there. And then there's been a case in France as well that Greenpeace have been on the receiving end of. Perhaps you could just give us some details of those cases.
Yeah, absolutely. Well, I joined Greenpeace International in 2015. Before 2016, and I'll get to the reasons for that in a second, we didn't have a proactive SLAPP resilient strategy. We were largely responding to SLAPPs, on a case-by-case reactive basis. But long before we had the data available to us through CASE and through the Business and Human Rights Resource Centre, there was no doubt that there was a growing problem of SLAPPs. That there was a trend, and the main reasons for that is that we just within the Greenpeace International legal unit saw more and more lawsuits materializing against Greenpeace campaigners, Greenpeace organizations, and so on. When I'd say two things. I would say that there are two main reasons that I think have triggered this real growth in SLAPPs. I think first of all, the rise in polarization and populism, which I think has made SLAPP plaintiffs more shameless in the way that they launch these legal attacks. It's easier in an age of hyper-partisanship and tribalism to stand up in court and say, for example, that Greenpeace orchestrates acts of eco-terrorism. But secondly, I think that plaintiffs have been more emboldened by the perceived success of legal intimidation tactics around the world. And Richard, you made reference to the lawsuits that we faced in the US, and I think those cases are illustrative of both of these trends. I mean, just to go through this very quickly. First of all, this growing shamelessness, I think, is really well exemplified in the cases we had in the US. So when I started work on SLAPPs in 2015, we had a number of cases ongoing, which had a number of recognizable qualities that you've already discussed. So for example, the extremely high claims for damages was one. The fact that many of these lawsuits would target not just the Greenpeace organization, but individual campaigners who worked for those organizations. These were common qualities we'd seen. One of those cases that we had was in Canada, which was filed against Greenpeace Canada by a logging company called Resolute Forest Products. And it was classic in many senses, an archetypal SLAPP in many ways. It was demanding 7 million Canadian dollars in damages. It was targeting 2 individual campaigners as well as the organizations. But it was archetypal in the sense of being a defamation case. And then in May 31st of 2016, Greenpeace International and Greenpeace USA and 5 individual campaigners were sued again by Resolute for the same advocacy activity. But this time they were suing us in the US under a US anti-racketeering law called RICO, which was designed to tackle mafia activity. And they did that by treating everyday acts of advocacy. So for example, letters sent to the customers of Resolute and other corporations as being criminal activity. So for example, those letters would be treated as extortion. Fundraising efforts would be treated as acts of fraudulence. And again, it's the sort of thing that you'd usually find, I'm just taking an example, the first line of the lawsuit that was filed against us by Resolute was Greenpeace is a global fraud. So it's the sort of language you'd usually find plastered in the sort of dark corners of the alt-right web in the US. And here it was being said by fancy lawyers in swanky suits and four-figure hourly rates in courts in the US. So that shamelessness was really something that struck us. And I'd say, it's no coincidence this was happening around the same time that Donald Trump was running for president. He was inflaming public rhetoric, and he was someone who himself is a prolific and notorious SLAPP litigant. The second thing I'd very quickly say is, the second trend I mentioned was about how corporations tend to learn from each other. So you'll see copycat lawsuits emerging. You'll see common tactics being replicated. Jill's already mentioned the fact that there's been more and more cases under data protection, under privacy law, especially in the UK since the Defamation Act of 2013 made defamation more difficult. You see some of these common tactics being copied and emerging elsewhere. And one really good example of this is it's again in the cases that were filed against us in the US. Like I said, they were filed using this anti-racketeering law called RICO. RICO is a law that was designed to tackle mafia activity. It has a long and notorious record of abuse, but it was only directed against advocacy in the late 1990s, first of all against anti-abortion protesters, then against animal rights protesters. But in 2011, this law, RICO, gained a whole new level of prominence as a weapon against environmental advocacy as a result of the case of Stephen Donziger. I don't want to go into huge detail because it's a very complicated case, but I think there are a few things to emphasize, and I would very quickly just describe that case. So in 2011, Chevron lost a case in Ecuador and was found liable for 18 billion US dollars, later reduced to 9 billion US dollars, in a historic and unprecedented case. And Chevron responded to that, first of all, by stripping all its assets from Ecuador. And when there were efforts to try and enforce that judgment in the US, Chevron then responded with this law, RICO. And they used that against Stephen Donziger, and it originally against all plaintiffs in the original Ecuadorian judgment, including the indigenous plaintiffs. And then in leaked documents found that they really shifted strategy to an attempt to demonize Stephen Donziger. So they focused it entirely on him. They used this law to paint him as being a racketeer, as being a sort of mafia type figure. And then ultimately they were successful. So they were able to get an injunction filed for the enforcement of this judgment. And that, I think, we can discuss whether or not this did actually represent a success. Chevron reputedly spent around $2 billion on this legal strategy. And the New Yorker, for example, published an article where it described that they could have, back in 2001, settled the case for a 6-figure sum. But regardless of whether or not it was a successful strategy, it was perceived as a successful strategy. And that really therefore popularized the use of RICO against advocates. So the fact that when we saw this case being filed against Greenpeace using RICO, that was one of the first things we thought was, that strategy is being adopted by these other corporations. And I realize I'm waffling on, so I'll get to a point in a second.
Well, it would have been a huge elephant in the room if you hadn't mentioned the Chevron case.
That's right.
I mean, you know, looking at it from the point of view of the communities who brought the case in the first place, what, 20 years ago or more than 20 years ago, they've almost been forgotten entirely, haven't they? Their interests. And this is one of the most regrettable things about this case, that their interests and rights seem to have been completely forgotten and sidelined.
I think that's a really important point. And I think it also underscores the fact that these legal tactics are often used in conjunction with PR tactics, PR efforts. So efforts to discredit, marginalize, and isolate the people who are being attacked, or organizations that are being attacked. It's really clear in the case of Stephen Donziger. Chevron spent a huge amount of money in their PR. You can still find their website that they set up for this purpose, just to really try to demonize and destroy the reputation of Stephen, so that people would no longer consider it a slap. And the same thing happened with the Greenpeace cases. We actually found out about the first slap in the US in Resolute because it had been passed over to the Washington Post, and we read it in the Washington Post before it had reached us. And there were, stories after stories of stories written by proxies trying to churn out some of these sort of smears that had been produced in the course of the lawsuits against Greenpeace. And there was a blog which every day would be updated with new attacks against Greenpeace. So you'll often see those two things go together. And as you say, Richard, it really is a means of distracting attention from the real issue. And making, I think Pring and Kanan talked about one of the effects of slaps being that, it transforms a political issue into a private issue. And that is very much a part of the tactics that are used by these corporations.
Yeah, thanks, Charlie. That's very interesting. Leanne, now in South Africa, I mentioned the case, the recent case, brought by Minerals Research Company, Minerals Resources Research, is it? I think it's Minerals Resources Research. And I mean, I know you were involved in that case, and according to the judgment, the judge concluded that the case had the classic features of the slap case, that the DNA matched. Perhaps you can just give us an outline of that case and the decision.
Of course, Richard. Mineral Sands Resources is an Australian company operating in South Africa. So Mineral Sands is the subsidiary of Mineral Resources in Australia. And what had really happened here is that both environmentalists and lawyers had criticized the company over violations of various environmental laws for mining that was taking place in the west coast of South Africa. So this is mining that's on the beach, many kilometers of beach and sand mining. And this arose also in the context of this particular company wanting to mine on the Wild Coast, which is in the Eastern Cape, and where communities had come out very strongly to say no to mining by this particular company, and had raised issues related to environmental rights, socio-cultural rights that were linked to the land that the company sought to mine on. And so mining has to date not commenced along the Wild Coast because communities have stood up to the company in that area. But on the west coast of South Africa, where they are still mining and where they're extending their mining operations extensively, former lawyers from the Center for Environmental Rights, as well as other environmental activists, had criticized the corporation, and this resulted in them being sued for about 14.25 million rand. And these were all defamation claims. Now, I'll come back to the factors in respect of the judgment itself, but this matter has been going on since 2017. So this is the 5th year in which this matter is running. What has been incredibly important is that in defending this matter and in CER, not an applicant in the matter or not a defendant in the matter, has been coordinating the legal defense of these cases. This is quite important because this has meant aligning strategies among the various defendants who are sued, looking at issues of resources and resourcing the case, engaging with pro bono lawyers around the defense of the case. And I think that's quite important in this discussion because these matters run over very long periods of time. So that gives you a bit of a context about the company and how we've coordinated the legal defense of these various SLAP suits. During the course of last year, one of the strategies that we discussed is the filing of a special plea that would raise SLAP as a legal defense to the defamation claim. So in the same way that a litigant would go to court and say a particular piece of litigation is vexatious in its nature, and it is designed or has been brought for an ulterior purpose, we decided to raise special pleas in each of the 3 matters, raising the vexatious nature of the litigation, saying that SLAP could be raised as a valid legal defense to the defamation claims. And judgment was handed down in February this year. Judge Patricia Goliath handed down quite an interesting judgment. You know, she could have handed down quite a plain and simple judgment that dismissed the exceptions that were brought by the company to the special plea. But instead, she really elaborated on why we had brought the special plea to begin with, and on what, as you've said, Richard, the DNA of a SLAP case is, reflecting on the history of SLAP. So some of what Jill has mentioned earlier in terms of how it arose in the US, etc. And this, I think, is quite important because in setting out what the factors are for recognizing the SLAP case, she has made it much easier for other litigants and defendants facing SLAP suits to then raise similar defense. And I'll speak about some cases where that special plea has been raised subsequent to the judgment being handed down. And one of the, some of the factors that she reflected on has already been mentioned by Jill. They relate to equality of arms. You know, this is generally brought by corporations that have much more resources than a civil society organization or an individual or community organization that is raising issues of environmental degradation and the impacts of mining, for example. You're looking at issues that are raised in the public interest. So it's not an individual that is claiming something for his or her private benefit. They are raising these issues because they relate to the protection of environmental rights. And importantly, Judge Goliath reflected on whether or not corporations were really trying to vindicate their rights. And I think this is important because if one took a step back and said, okay, there are activists that are raising concerns about breaches of environmental laws, licenses, etc. The corporation could have very well said, look, we hear you. We want to have a discussion in relation to what these violations are. We want to receive the evidence. We want to address these concerns in a meaningful way because as a corporation, we want to ensure we have a meaningful social license to operate in the community. But instead of doing that, they chose to lodge a defamation claim as a private law dispute, and lodge it in a manner that cited a high amount of damages, and which would be long and drawn out and really siphon away resources from the organization. So I think the setting out of the factors for recognizing a slap in the Goliath judgment has been incredibly important. And it has brought visibility to an issue that I think really requires this kind of visibility.
Leanne, if I can just interrupt for 1 second, just as you were talking, I was just looking at the UN guiding principles, and in Pillar 2, which is the corporate responsibility to respect, corporate duty to respect human rights, there's in paragraph 18 a section which talks about the assessment of adverse human rights impacts by business enterprises. That businesses should seek to understand the concerns of potentially affected stakeholders by consulting them directly in a manner that takes into account language and other potential barriers to effective management. In situations where such consultation is not possible, business enterprise should consider reasonable alternatives such as consulting credible independent expert resources, including human rights defenders and others from civil society. So I think that highlights your point that rather than resorting to these private civil slap suits, that would be the appropriate response of a responsible business that was genuinely committed to its human rights obligations.
Yeah, of course. And it's just a question of motive, which was raised also in the judgment. What is the motivation of the slap suit? And, at the end of the day, civil society was distracted by these slap suits. And, we had to really come together, and CR and other organizations had to continue objecting to extensions of the mine operation, for example. We had to continue doing the work that we needed to do, and that was the primary work that we needed to do. But that is an incredibly difficult thing to do, where you're having to deal with the slap suit, but also deal with the direct issues on the ground and the continuing violations, etc. And this just in this last quarter, we have seen 2 more slap suits also against those acting in the public interest, and where...
Sorry, just to interrupt again, sorry, that case is being appealed, is it, that decision, or is that the end of it? Right.
Yes. So this case is, I know this is important, Richard. This case is there are 2 separate appeals. The corporation is appealing the outcome in relation to the finding of slap being a valid defense, whilst the defendants are appealing the finding that a juristic corporation could be sued for defamation without alleging patrimonial loss. So you have 2 separate appeals before our constitutional court, one by the plaintiff and one by the defendant. And we're waiting to hear from the constitutional court whether or not our matter will be heard, because I think having a constitutional court judgment on this will be really just highly valuable in settling some of the issues, because the second part of the special plea related to the fact that a corporation could sue for defamation without calculating or illustrating to the court what kind of patrimonial loss had been suffered. And this is highly problematic, because you could estimate that at any amount. And so therefore you have these very inflated amounts without any real proof of actual damages. And
you mentioned two other cases as well. If you could just mention those very briefly.
Yeah, of course. And I see Claude Kabembe from Southern African Resources Watch is on the call as well and listening in. But you have two cases. The first, a Canadian company suing the Southern African Resources Watch over allegations made about their operations in Zambia. It's interesting because the allegations relate to Zambian operations, but they're being sued out of the South Gauteng High Court in Johannesburg, because Southern African Resources Watch is also based in Johannesburg. And you have a second case where a property developer, Century Property Developers, is suing the Greater Kyalami Conservancy over allegations made about the property development. And in both of these cases, in which the defendants had to then put in their papers in response to the claims, they have raised the special plea in the same way that we have, alleging that or raising the fact that SLAP has been recognized as a valid defense to defamation claims and amounts to vexatious litigation. So we are watching those cases very closely. We are engaging with the defendants as well to share the kinds of experiences that we've had in the MRC case.
And just finally, Leanne, why have there been so many of these SLAP suits in South Africa? Is there any reason?
It's quite an interesting question, because on the one hand, you could say, look, these corporations are under some sort of increased pressure to be able to push forward their developments. They may want to sidestep environmental guidelines, licenses, rules, etc. And so are coming up against communities that are concerned about those violations, right? And want a quick and easy way out of addressing the allegations. So instead of getting a really expensive independent expert to come and assess what the claims of the communities are, they would rather, in quite a dismissive way, lodge a SLAP suit, right? It's an easy way to also attack the credibility of those who have made the allegations. On the other hand, you could say that, well, civil society organizations and activists are having a real impact. They're using social media in a really clever way. They're able to get to the corporation. They're able to highlight non-compliance and highlight conduct that is harmful to the environment and to human rights, and is a real thorn in their side. And therefore, corporations are having to then take action to respond to them. So is it a narrowing of civic spaces, or is it the fact that in using and exercising constitutional rights and the right to freedom of expression, activists are having a real impact on these corporations? But either way, I think the trend is not a good trend. But I think what is quite important is that we have a lot more people who are able to identify these SLAPs and share their experiences so as to ensure that they don't achieve their objective. Activists are not ultimately silenced, but are instead empowered to stand up against the corporation.
Thanks. Now, Jill, the media and journalists are often the targets of these SLAP suits. And I saw reference to a 2018 study by Greenpeace and the University of Amsterdam, which found that defamation was most commonly used, particularly against journalists investigating corruption or exposing corporate abuses. And I think people will have heard of the case of Daphne Caruana Galizia, the Maltese journalist, who I believe was subject to quite extensive SLAP suit claims. I mean, perhaps you could just summarize your view of cases that are brought against journalists and the impact of those.
Well, I think, again, as we sort of discussed and touched on, there's always a lurking issue here around whether there is some ground for a complaint. And again, we've touched on the sort of proportional way in which you might try to resolve a dispute, which is not necessarily by going down a prolonged legal battle in quite a lot of cases. There are other ways to deal with it, particularly because, well, as Leanne and Charlie will well know, these companies tend to be very well resourced in terms of the PR side of things. They don't need to deploy armies of lawyers per se to get the result they want to try and win the argument. But and as I said, in the UK, it started focusing, or we've identified it as focusing on media issues. We've put this term slap around cases that we might not have used that terminology around back in the day. We talked about libel tourism back in the day. We didn't sort of see it in this rather more collective way. I think you mentioned Daphne Caruana Galizia. She had up to 40 civil and criminal lawsuits against her at the time of her death. And quite a lot of those, quite a high proportion of those, were from politicians in Malta who were threatening her, suing her in the UK, and were from businesses, from banks, from an American bank. And you sort of go, well, why are they, these enormous entities, so worried by this one woman writing these things that they feel they've got to go to these extreme lengths? And it's the power of speech and the power of good journalism, if you like. So in the UK is it's a favoured regime when you can get your foot in the door here. We've got the burden of proof that is on the defendant, which can cause problems and can make it tricky sometimes, particularly if people aren't familiar with the way that the UK libel law works. So the fact is that post-Brexit, slightly harder, but before Brexit, it was relatively straightforward to sue a Swedish company or a Spanish company here, a Greek company here for their publications, even if they were in Greek about Greek issues or Spanish issues. Particularly if the claimant is a UK-based claimant, it's relatively a shoo-in for the courts here, without rather looking at where the real damage is done. If you've got a Spanish language paper or a Swedish language paper writing about local issues, you sort of think that that's where the damage is done, and that the lawsuits should end up in those courts, not in the UK courts. And I think,
Jill, why do you say that the UK is a favoured location for these cases? It's because of the nature of the defamation laws here, as opposed to
partly the nature of the defamation laws, partly the costs regimes that exist here, partly the very draconian disclosure laws that operate in this. If litigating in the UK is a very, very different kettle of fish from litigating in Europe under the civil law regimes that they exercise there. They don't have enormous disclosure. Yeah. They don't, like in Sweden, you can't sue individual journalists. You can sue the organization, but you can't sue the individual. We don't have any of those sorts of rules. The Defamation Act 2013 made a difference with serious harm and the Section 4 defence. But the fact is that even if you've got those protections, particularly the Section 4 defence, you're still going to have to go through a very, very long and expensive process to possibly ultimately come out the end successfully. So
as a defendant, you face problems with the burden of proof. You've got perhaps significant disclosure obligations that you'll have to meet, disclosure of your electronic as well as paper documents that you wouldn't have to the same degree, to anything like the same degree in European Union, and very punitive cost sanctions if you lose the case.
Well, and the fact is that the fees that are charged by UK lawyers, obviously accepting lead A from any sort of criticism of that, when I look at what I pay to an Italian lawyer or a French lawyer if I need advice, it's generally an awful lot cheaper there than it is here to get legal advice and to get things defended. Partly because the court process is actually, although it can take an awful lot longer sometimes abroad, it's more straightforward. And because they don't have these stringent source disclosure issues, for example, journalistically, you're worrying about source disclosure, what you should be revealing, all sorts of really quite complicated issues that can arise. Whereas it doesn't tend to work like that if you're litigating in Europe. And in Europe, generally, the damages awards are lower across the board. So, it is very attractive coming here.
And if you put something online, then if it's read here,
yeah,
then you're caught with English jurisdiction.
Well, there's that quite old case now, probably the turn of the century, Dow Jones and Gutnick, which is an Australian High Court case, I think, where it basically established that anywhere that something can be downloaded in terms of publication, you can generally think about getting a legal action going on the basis of. So yeah, that's opened up things quite considerably.
But forum shopping is not so easy now in England post Brexit.
It can still be done. It's just that I think the main change is that whereas pre-Brexit you could sue here for all the damage occurring anywhere in Europe, now post-Brexit, if you sue here, assuming you've got the reputational connections, you can just claim for damages in the UK. I think that's so there's not, you can still do it. And if you still want, therefore, tactically tie people in knots, if you're not really interested in the outcome and the damages, the suing in the UK is, England and Wales, let me be clear, is still quite an attractive route.
You mentioned a Section 4 defence. What is that exactly?
Section 4 of the Defamation Act 2013 is a public interest defence. I mean, we're not allowed to call it responsible journalism. It originated from a case called Reynolds against the Times, again, longer ago than I care to think about. But that basically, Section 4 defence says, if you're reporting on a matter of public interest and you have reasonable grounds to believe that it was in the public interest, you have a defence. The downside of that defence is that it is all about what you, the journalist, have done. So it involves everybody crawling all over your pre-publication processes. The old-fashioned defence of truth, which is about evidence, is on one level much more straightforward and much less exposing for the journalistic organisation, but obviously comes with its own risks.
So this is a defence that's available to journalists, but not to organisations, environmental organisations or human rights organisations. Would that be right?
If they're sued for defamation over something they've said or done in a publicity statement or a leaflet, yes, they can avail themselves of the defence. It's not just a journalistic defence; it's a public interest, publishing public statements on matters of public interest. So it's quite wide-ranging in that sense.
Now, there's a case recently slap suit brought by a Kazakh mining company, ENRC, which has been against the Serious Fraud Office. I mean, it's quite a remarkable case from what I've read. And they've also taken action in the US, this company. I mean, can you shed some light on that?
I can't possibly say anything about them because I'll probably be written to immediately, given that they seem to have a propensity to complain about any mentions of them whatsoever. I mean, I've heard
in that case as well.
Horrendous stories about journalists writing to them on a pre-publication right to response basis, and they get met with an absolute deluge of lawyers threatening them. It's very hard. I mean, it's all in the public domain at the moment, in the sense that they're suing their ex-legal advisors because they've all fallen out about the strategy over initial complaint. But yes, they've got actions against the SFO, which may be fair or not. The SFO looked into corruption investigations and pursued them on that basis. But again, if we're looking at the sort of, as we said, the sort of purpose of some of this. Some of it seems completely pointless in terms of litigation and an outcome. And when every time a journalist tries to sort of discuss the case, go through the issues and the pros and cons and gets met with enormous legal letters, you've got to start thinking about that as being an abuse, an attempt to silence any discussion of what's been going on in the case. And the substance of the case way down is about what their activities were and what they were doing, and it's very easy to forget that because there's so much tip of the iceberg stuff on the other side.
Well, the idea of a slap suit to stop an investigation into corruption by the Serious Fraud Office is quite worrying, isn't it?
Yeah.
Well, okay, and the action that they've taken in the US relates to the same kinds of issues, does it?
I'm not overly familiar with what's been going on in the US. I don't know if Charlie knows anything about it or anyone else. I would imagine that it covers the same sort of ground, but I don't know what the lawsuits are there.
Okay. Well, I mean, there's a lot to digest there, and a lot of examples, and I'm sure that, as they said in the Business and Human Rights Resource Centre report, that we've just been touching the tip of the iceberg with some of these examples. But perhaps, I mean, we can just sort of take stock of the current position and summarise the concerns that we have from our different perspectives about these slap suits. I mean, first of all, from a journalistic perspective, I mean, you've explained the position, Jill, but I think in a paper that you've written, you also make the point about the right of the public to be able to complain about government and the chilling impact that a slap suit could have on that right.
Yes, I mean, I think it's fair to say that in England and Wales, we don't tend to find governments and politicians using the law. They've moved on. I mean, there was a period of time when they did, but they have moved on from that. Our democratic processes seem to have come out on top in that basis. But in other countries where the democratic systems may not be so resilient, there is a lot of use of government and politicians suing, making up the bulk of those who are suing. We mentioned the actions against Daphne back in the day. A lot of those were by politicians. So, if you don't have a regime and you don't have a system that says basically government and state organizations can't sue, then that's a problem. The other problem that lurks in a lot of defamation cases is that in a lot of jurisdictions, defamation isn't necessarily just a civil case, it's a criminal case. So people can end up being threatened with, ultimately in prison. And Strasbourg's very strong on the use of criminal sanctions against journalists or potential criminal sanctions against journalists. And all of that has a chilling effect. If you're worried about getting a criminal, being sent to prison, I mean, you only have to look at Russia or Turkey or Egypt or the Philippines, what's going on in Myanmar at the moment, to see how easy it is to use the law to threaten your political opponents. And that does come back to the key thing that we said at the beginning about allowing people to express their opinions and likes and dislikes is one of these fundamental rights.
And Charlie, in terms of corporate accountability, slap suits are pretty negative, aren't they?
Yeah, well, that's the whole purpose of slaps, is to avoid scrutiny on difficult issues and inconvenient truths. It's mainly to create a climate of fear that people will not even consider challenging them anymore. And I mean, I don't want to mention them here because it would suggest a sort of success strategy, but there are, I know historically there have been some companies which people are always reluctant to touch as a result. Just building on this idea of a chilling effect, it's notoriously difficult to document for a number of reasons. Most of the time, the intimidation is such that people are scared even to talk about the legal threats they receive. And often, moreover, people don't want to, admit or to acknowledge the fact that they've been chilled, that they've retracted statements. I can't submit articles here, but there is a really interesting and incredibly unusual article that was written, I think, in 2019, simply entitled "Why We Didn't Publish," and it was published in the Nevada Independent, so it's in the US. It's a really interesting article to look at for this, because it's so unusual to have a publication come forth and say, or an organization come forth and say that we didn't. And there they said things like, for example, if we were to go public then and admit that we declined to publish a story, would that send a message that we can be rolled, that we can that we can cave in really easily like that. And so that's, I think, a key reason. Every now and again, you see a case that leaks through to the public eye about a documentary or a newspaper or a book which has been blocked in the UK or published in the US, for example. I mean, the most famous example of that was the Going Clear Scientology documentary and the expose that came before it, which was never shown here, but it was shown in the US. But for those of us who are working on issues of corporate accountability, this is very much the tippiest tip of the iceberg. The problem is that legal intimidation, not so much slaps, or not necessarily slaps, but legal intimidation has been normalized as a tool of reputation management. So for example, we often talk about some of these big corporations who don't necessarily have a good reputation already. But even with a company like Facebook, for example, which, I mean, although its reputation has taken a battering in recent years, it certainly tried in the past to create a more fluffy and progressive appearance. But post the Cambridge Analytica scandal, the first thing it tried to do, as Jill will probably be able to tell better than me, was to issue legal threats against those who were exposing that scandal. So yeah, I'd say these are real issues in there, and I think that's why it's so important. I know we will talk about solutions later on, but I think that's why it's so important to challenge that norm and to delegitimize the use of slaps as an acceptable reputation management strategy, as that euphemistic language goes. And I think I would just end very briefly on a positive note, which is that this really is starting to happen. Only yesterday, a group of investors and 44 financial institutions with more than $270 billion of combined assets came out and released a letter where they said they called on corporations to do more to resist and to combat the use of slaps. Again, I think that'd be a useful thing to send around here. But you are starting to see, as we raise awareness of slaps and we raise awareness of the human rights implications of slaps, you're seeing more investors and financial stakeholders recognizing that they have to call this out, they have to call out this activity, and that they have to challenge the norm of slaps as a business strategy.
Well, that's a positive note to end that point on, Charlie. I mean, we've mentioned, Leanne, we've mentioned the UN guiding principles a couple of times, and many of these companies that we've discussed claim to follow the UNGPs. I mean, do you think bringing slap suits could possibly be consistent with following the UNGPs? It's a rhetorical question, really, isn't it? But
yeah, I mean, it's interesting because you do have corporations that will try to, on paper, establish quite a good corporate social responsibility kind of reputation, and do all the kinds of things, tick all the boxes, etc. But at the same time, use these kinds of tactics to silence critics. And it has always been quite interesting to me that, I mean, when do they consult their PR people in relation to bringing a slap suit? Are the lawyers speaking to the PR people? Like, who's talking to who? Because at the end of the day, these SLAPP suits are having a negative impact on these corporations and their seeming commitments to corporate social responsibility. And I mean, from where we are, we don't see that as making much sense, but clearly they are weighing up the pros and cons and thinking, look, this is a good thing for them to do somehow. Yeah.
Well, I mean, as you say, they're probably different parts of the company, of these businesses pulling in different directions. And as Charlie says, hopefully some of the more ethical or responsible or sensible investors will hold sway when it comes to this. Let's talk about some of the solutions then. What solutions would be appropriate? What reforms are needed? Jill, I think in your paper, you talk about some of the procedural mechanisms that are available, for instance, under the civil procedure rules in the UK.
Yeah, so we've touched on some things, which is that certainly in England and Wales, it would be helpful for there to be more recognition of the possibility of a SLAPP and the creation of a process that is focused on just identifying whether that is a SLAPP. And that's not saying that, in every case that there's not going to be full-blown litigation over something, but it's for a court in an early stage to do some sort of balancing act. And there are provisions both in the Defamation Act around summary judgment and in the CPR rules about abuse of process. And how you define abuse of process goes back to some of the more nuanced issues that we've been talking about. But also, we all know, those of us who are litigators, that the overriding objective in litigation is still around fairness and proportionality. And it does seem to me that there is a consideration there that can be deployed, and we may need to be a bit more forceful about deploying it in that way. I mean, I also think that in addition to sort of calling for some procedural mechanisms to be recognised and put in place, you've mentioned the UN guiding principles, and that's soft law, but holding businesses to account, because it's not a international treaty. It's not an international treaty, but it's as I say, soft law, but it's not something I'm overly familiar with. But it does impose duties on corporations that go down to the organizational level rather than to the state level, which is where, of course, a lot of the law, the European Court is on governments, compliance, and although they have some positive obligations to make sure things happen, it's a much harder process. So, if we all start doing these things more regularly and using this language and accusing people and trying to raise the profile generally of saying, well, this is a case where you're going to have to justify why you're bringing this claim, I think that would also be useful. Finally, just one other thing from me. I mean, we've discussed and mentioned the chilling effect, not just of bringing the legal case, but of the letters that you get before you get anywhere close to being sued. You get put off before you've even published the thing, and that's the aim of the exercise. So I think, one of the things that some of the groups have been discussing is whether there is an issue around English lawyers and the way they write their letters and the threats that they make, and whether they're making effectively unjustified threats, and the tone and content of those letters, and whether there is anything that the SRA should be doing or giving guidance on in terms of how these things are set out, really. So that's just some of the possible solutions that there are floating around.
Just to come back on the UN guiding principles, I would suggest that the state does have an obligation under Pillar 1, which is the state duty to protect human rights, to prevent the misuse or the abuse of these SLAPP suits. So I think probably you could invoke the UNGPs against states as well. Yeah, Leanne, what's your view about the key reforms or solutions that are required?
Yeah, I mean, I think the data that Business and Human Rights Center is putting together is something, the data collection and being able to establish the trends and saying, look, 3/4 of these cases is in the global south, for example, is really important, because sometimes when we're dealing with these issues, it's important to say, this is what is happening, and here are all the various iterations of SLAP. Because as we've mentioned, the report doesn't just say, look, these are all SLAP cases. They say they bear the hallmarks of SLAP. And I think that kind of work could be replicated in different regions, in different countries, so that you create a real rich database of trends and occurrences and identifying factors. Because some of the major obstacles that I think are being faced is just, are people not reporting SLAPs, or are they not recognizing it as being a SLAP because they can occur in so many different forms, such as criminal, interdict, etc. And I also think that being able to ensure that there is a campaigning aspect that is attached to the legal defense of SLAP suits is quite important, because you have to empower those that are being intimidated and silenced, harassed, to continue to speak up against that kind of harassment, or ensure that the issues are being spoken about, even if they are fearful to speak about the issues themselves, because of the SLAP suit or for any other reason. And I think lastly, there's a huge question of resources. Whereas funders, philanthropy is putting money towards the realization and the advancement of human rights, environmental rights, etc., they must recognize that the effect of doing that work can be these SLAP suits, and they can be expensive and lengthy. And I think specific funds could possibly be set up to address this, just as you address the physical harassment and intimidation of activists.
Thanks. Charlie, there have been proposals for reform at the European level, and I think you've also had experiences from CASE. Perhaps you could just summarize those.
Yeah, happily. So the Coalition Against SLAPs in Europe, or CASE, has been calling for an EU directive to be passed to ensure uniform minimum standards in place to ensure the protection of public watchdogs who are facing attack. This is in many ways modeled on a number of successful anti-SLAP laws elsewhere. And I think you'll find with many but I mean very much adapted to an EU context. So therefore it's very much taking into account the various different jurisdictions that this would apply to. And as I said, therefore, it provides those minimum level, the minimum conditions that need to be there present for SLAPs to be tackled. But I would say most anti-SLAP laws that you see, that successful anti-SLAP laws, the effective anti-SLAP laws, will have three core components to them. And this is seen in the model anti-SLAP directive that has been drawn up and advanced by CASE. The first of those is that it will involve some sort of accelerated procedure, so proceedings. So of course, SLAPs, has already been commented, work primarily through the litigation process, not through the outcome. So SLAP plaintiffs will generally try to stretch out proceedings as far as possible so as to make those proceedings as painful as possible for the defendant. So the most obvious way and the most effective way of combating SLAPs is to have an accelerated procedure so that you can filter out those abusive claims as quickly as possible. And again, in terms of how this is applied in different jurisdictions, an anti-SLAP directive would leave some legroom in terms of implementation. In the US, the way that's done is it will introduce a heightened standard at that early stage. So, for example, in the US, you would commonly have a motion to dismiss at the early stage. And the plaintiff in those cases will only have to show a plausible chance of success at trial at that point. And the anti-SLAP law, when it's invoked, will have a higher threshold, so that the plaintiff will have to show a probable chance of success, which makes it harder. That's the first part. It's not sufficient on its own, because even if you have an accelerated procedure, often that will take a whole year, for example, at least a year to get to that stage. And in that year, if you've got high legal fees and you have no other protections for public watchdogs, that in itself will represent such a drain on resources that it will be enough to have its effect. So the other two components that you'll often see, first of all, is sanctions. So sanctions for those who use it. And that also has the additional effect of being able to deter further slaps and delegitimize the use of slaps. And again, those come in many different forms. It might come as an automatic award of costs, or there might be, for example, exemplary damages imposed against the plaintiff. And finally, and this is the last thing I'll say, and again, this is in the Model Anti-SLAPP Directive, there are some protections for public watchdogs. So that would be, just in terms of being able to cover those legal costs. Because even if ultimately at the end of the process, you're able to recover your fees from the plaintiff as part of an anti-SLAPP law, often that process, paying lawyers upfront with the uncertainty involved of whether or not you're going to see that money again, will be enough to force a retraction. So it's important, therefore, you have measures in place to ensure that public watchdogs receive that funding at the early stages so that they can cover the costs for them. And again, that can take many different forms. It could involve an expansion of legal aid regimes, or it could involve some sort of fund set up for public watchdogs who are under attack. And yeah, the model directive has those three things present. And so that's something that we're really pushing for in case at the moment.
Great. Well, there've been a few questions that I've had a few emailed to me, and I think there are more on the Q&A. But perhaps let's go through the ones that I've got here. The first question here is, there has been a proliferation, largely via social media, of fake news, with irresponsible actors widely communicating incorrect information as facts. The court sometimes, via defamation lawsuits, seem to be one of the only fora where there can be a full and fair examination of the allegations and a decision with respect to the accuracy of those allegations. How can that be balanced against needing to prevent slaps? Should small critics and large multinational critics be treated the same in slaps? That's interesting. Jill, do you want to comment on that?
I thought I saw Charlie putting his hand up on that one.
Well, Charlie, I don't mind. Charlie, if you put your hand up.
I didn't want to jump the queue. I just had two thoughts which came to mind very briefly. I'll just emphasize really quickly, and I will try to be quick. The first thing is that, yes, there should be different standards for corporations. And that's something which has been recognized by the United Nations and by the various different regional human rights bodies, that corporations are public figures. And actually, we spoke about the McLibel case. This was something recognized in the Steele and Morris case in the European Court of Human Rights, which is what McLibel went on to become in the European Court of Human Rights. One of those things was that there has to be a higher threshold for corporations who are seeking to have their reputation vindicated in court. But the second thing, and this is the thing I'd really emphasize, is to go back to the definition. SLAPs are abusive lawsuits. They're not lawsuits which are designed to vindicate rights in court. That's not the purpose. They're lawsuits filed with an improper purpose, and that purpose is to silence criticism. So no one who campaigns against SLAPs is campaigning against the right to have your reputation vindicated in court, and certainly not to combat the scourge of misinformation online. That's all I'll say. And sorry, Jill, to jump ahead.
No, it's fine. It's given me time to have a think. I mean, I think, fake news is a bigger, different problem on one level, although there's clearly an overlap. And one of the difficulties with it is the extent to which you allow the social media companies where a lot of this stuff appears to police it and censor it themselves. And if they do that, the extent to which that is a transparent process. And, we've seen some shifts in that, from the days when these big social media platforms said they weren't publishers and didn't have any liability and pushed it all somewhere else. That world seems to very much have moved on now. They, even if they're not expressly calling themselves publishers, I think they are much more recognizing their rights and responsibilities. They have terms and conditions that can be applied and that can be managed around that. I think one of the interesting things, again, talking about the UN guiding principles, is those principles would seem to me to apply to Facebook. So there is sort of soft law that can be deployed. I mean, some of this is proportionality. Is it proportionate to use UK libel law over something that is said to be inaccurate? Most of the UK newspapers, if it's not defamatory, i.e. it doesn't go to reputation, have codes of practice, whether it's ipso or impress, or in the Guardian's sense, it's editorial code, that deal with accuracy issues. And so there's always been an acceptance that, inaccuracy is something that isn't necessarily got to be a legal issue. So putting that through the court process all the time, is disproportionate. And as Charlie said, what we're talking about here is something that is actually quite different. The purpose of it, the purpose of the false news may be malicious and abusive. They're both problems with speech generally and the internet and the digital era. But I think they're very different in reality, as Charlie's articulated.
And the key to it is the purpose, isn't it? If the purpose is simply to vindicate your rights, to clear your reputation, that's one thing. But if it's really to silence people through legal action,
as Charlie mentioned, in the Steele and Morris case in Europe, there's a very strong line there that something along the lines of, in a democratic society, even small and informal campaign groups should be enabled to contribute to public debate on matters of general public interest. So there is some useful stuff that can be very helpful from some of these European cases, although not much, but it will start coming through, I think, more.
And Leanna, it's quite difficult, isn't it, if you're a small NGO to necessarily get everything right. You might, for instance, produce a report. I come across a case like this a few years ago, actually, where an NGO produces a report. There's a lot of criticism that seems to have quite a lot of validity to it, but then they may have overstepped the mark with a statement that they've made, perhaps not supported with good evidence. And if you're not a well-resourced organization, that's an easy mistake, an easy slip up to make. And the consequence of these slaps seems to be that those kinds of organizations would have to keep silent all the time if this was to go on.
Yeah, I think on the one hand, there is the ability of the company to respond, to provide some sort of correction or public response that is directly responding to the allegations with evidence, with whatever it is that is needed for them to address the direct concerns to their reputation. And that, I think, can be quite easily done, like we've discussed. And it really is then about proportionality and what the impact then is. If you have to issue a slap suit every time an organization got something wrong or had some factual errors in the report, that is really a direct violation of their rights to freedom of expression, and to do so in quite a robust way. I think, corporations are sometimes even more powerful than some governments. And so to some extent, they must be able to deal with allegations in quite a robust way, and have the wherewithal to address any types of allegations that come their way.
I don't know who's going to answer this question. I have requests from Armenia where slaps are increasing. What European Court of Human Rights precedents can be helpful for us activists to push Armenia's courts to recognize slaps and dismiss company claims, as could be done in the US and Canada?
I can start if you like. I'd start by saying, well, a number of things. First of all, I'm really interested to hear about this these new slaps, waiver slaps in Armenia. We're currently looking to, as I said before, map out these slaps and catalogue and identify them through case. So please do go to www.the-case.eu. We'd love to hear from you. So do get in touch and tell us more. But to answer your question, it wasn't meant to just be a gratuitous plug. But I would just say a few things about European standards. I think the first one we've covered already, which is this heightened standard. So suits by public figures, and that includes corporations seeking to protect their reputation, must meet a high threshold. There's a lot of jurisprudence from that from the European Court of Human Rights. I think there are another two principles which are equally important in the context of slaps. One is something which has been raised before as well, and Richard started when he introduced the topic, which is about the proportionality of damages. So there are a lot of cases, and actually this was, again, we go back to Steele and Morris, this was also captured in the Steele and Morris judgment, which was this idea that disproportionately high damages when imposed on activists and other public watchdogs can be an unjustifiable infringement of Article 10 of the European Convention on Human Rights. Again, that's in that judgment and has been spoken about lots and a number of other cases too. And finally, legal aid. This idea of an imbalance and inequality of arms. That's also something that has been recognised, where you, and again we go back to Steele and Morris, but where you don't have the ability to fight on an equal basis against a lawsuit filed against you, that can also be an infringement of Article 10. And we've written a bit about
Article 6, I guess.
Yes,
hearing.
That's absolutely right. And actually, I think that particular provision, part of the judgment, was in relation to Article 6. This is something we've written a bit about. Again, maybe if we're sending out links, I could send you, we could send out after this call a journal article we've written about some of the European Court of Human Rights jurisprudence.
Good.
And
there's a question.
Sorry, just to chip in another couple of things, sort of on the back of what Charlie said. Obviously, there's quite a lot of European Court jurisprudence on the use of criminal defamation. I don't know what the law is in Armenia, whether it's a criminal or a civil or both, but there's a lot on that. And then, of course, we come back again to the UN guiding principles, which are there, as a wider set of principles for holding corporations to account as well. So I think there is quite a lot there, and at the bottom line, you've still got handicide in Europe, which is the starting point for saying you've got to tolerate quite a high level of criticism. That's part of the free speech bargain that there is.
That's the name of the case, handicide.
Yeah, handicide versus UK. I mean, it's a very old. I think I'm probably older than I.
Okay. There's a question here. I don't know if anyone can answer this one. Is there any research that finds correlation with slaps and corporate arbitration against states? The successful slap leads to a successful potential investor-state dispute settlement litigation. Anyone know about that?
I could say one thing very quickly. The go-to case on this, or the relationship between ISDS and slaps, is going to be Stephen Donziger. Well, not Stephen Donziger, sorry, it's going to be the Chevron case. So Chevron was avoiding paying that judgment I was referring to earlier in a number of different ways. One was through its slap against Stephen Donziger, and one was by suing Ecuador using the ISDS mechanism. I don't know a huge amount about that case, but if you're looking to look at that sort of relationship, Pablo Fajardo, who is the lawyer for the things, has done a lot of work, and his group's done a lot of work on that, and that's all I can really say about it. But that would be the place to look.
Right. Okay. Well, that's probably where that question stems from then. Right. Well, look, I think we're going to leave it there, and I just want to end by thanking the three of you for this very illuminating discussion. I'm sure it's given everyone a lot of food for thought about this quite intolerable state of affairs that seems to have increased around the globe. But it sounds from what you're saying as though a lot of momentum is building in various countries to counter these SLAPP suits. And you've given us some good ideas about what needs to happen to make these things a thing of the past, and including cooperation, I think, between different organizations and sharing resources and helping each other in the face of very well armed, very well resourced opponents. So I wish you, all the three of you, all the best of luck in achieving those goals. And yeah, thank you again for joining us, and thank you to everyone for joining us today. I hope you found it as interesting and worthwhile as I have. Thanks very much.